First order proceeding today is I want to show you all the child interviews. So I'm going to share my screen and y'all are going to get a chance to read it. I'll give you all 5 minutes each page before I turn it to the next one. If you get finished early, just let me know. Just, let's see here. There we go. Can y'all see that?
Yes, Your Honor.
Yes.
Okay.
I'm good, Your Honor.
You can move forward.
All right.
I'm fine, Your Honor.
All right.
Okay, so we're here. Generally, I give each side 30 minutes, tell me additional, and to ask any other questions of witnesses. Is there anything else that y'all want to address before we do that?
Yeah.
All right. I just filed a special exception. I didn't know if we were going to have time to hear that today. Or if I need to reset that depending on the court's availability today.
Yeah, I really didn't set that today, so you can reset that to a different day.
I will. Thank you, Your Honor.
I have a couple of questions.
Yes, go ahead, sir.
I want to clarify a couple of things that I haven't been given any information on or any response to in any kind of writing. For instance, who the plaintiff is to begin with.
The petition was filed by my mother.
It was filed by Rhonda Doe.
Yes.
Okay. Did she do so according to Title V, Section 156.006B1 that requires her to do so with an affidavit?
Okay. Mr. Conacher, you want to address that?
Yes, Your Honor. My understanding is this is a modification case, and we are trying to modify a
Mr.
divorce decree from 2011.
Mr.
And
Busham?
Let him respond, sir.
Well, I have an issue with him speaking since he hasn't been sworn in, and everything he has to say is hearsay evidence.
He's stating his position. He does not have to be sworn in to make any statement.
Even though the knowledge that he has is hearsay.
It's in the nature of argument. It's not sworn. It's type of statement. It's not sworn. Mr. Conacher, go ahead.
Thank you, Your Honor. Yes, as I was saying, Your Honor, this is a modification case of an order from, I believe, 2011 divorce decree, and I represent the SEA Commissioner Ron Doe, and we are here in court to try and make an argument as to what is in the best interest of the children currently, and we are asking for the court to make orders with respect to conservatorship, possession, and access to child support, mainly for temporary movers today, Your Honor. And as to Mr. Olivas is suggesting that this isn't in line with whatever code section he's referring to, I wasn't clear if he's referring to the Texas Family Code or some other statute.
He's referring to 156-006, modification of primary on temporary basis.
I see. And Your Honor, with respect to that specific provision of the Family Code, if we are going to address primary today, we certainly have the ability and right to request that the court look at the possession and access schedule. We're not going to touch the issue of primary today, Your Honor.
I object to that for the very specific reason that I received paperwork and it said it was a temporary orders hearing, and specifically it mentioned that part of Texas Family Code. Therefore, in regard to that code, it specifically talks about her having to do so in a form of an affidavit, or even if you want to go and further say, you know, that it's not required. Well, Mr. Conacher was very, very helpful in saying that any kind of motion or petition or any kind of order that's before the court has to be done so as per Rule 47 with an affidavit as well, and there has to be some sort of appearance by the petitioner in the court in a way of an affidavit, regardless of which way you want to look at it. There cannot be a petition by hearsay evidence by an attorney who's got no firsthand knowledge on anything in regard to my sons or myself or any kind of anything. I've never met the man. I didn't have sexual relations with him, so he doesn't know anything about what this is entailing. Therefore, Rhonda has to have appeared before the court. Has she done so through the form of an affidavit of some sort, or even any kind of appearance officially? Because I've gone down to the records department and they have nothing.
Okay, when we look at section 156.006, that addresses solely requests to modify primary on a temporary order basis, but not to modify any other order, i.e. child support, possession, and access, that type of thing. So the only pleadings that mother has on file to change the primary is based on child preference. An affidavit is not required under the code for that particular request, but it only applies to bond.
Well,
So there is no request for primary in regard to the other child support. So that is not important. No request for changes of possession and access to support and all those other type of things are still before the court.
well, the question for being the question for me asking that is very specifically, the paperwork that I received said it was for temporary orders, and under temporary orders, it has to be for something that hasn't been done under a final order yet. In my case, or in this case, a final order has been issued, and she didn't file for an enforcement, and she didn't file for a contempt order under the final decree of divorce. So if she's filing outside of the final decree of divorce, then something that she's doing is obviously not in accordance with the final decree of divorce. And for the court to not enforce its own final orders is in contrary to its own rules.
Okay. The court's ruling on this is that the modification is properly before the court on certain issues. Some issues are not pled, change of primary regarding the child.
Some
Court, although the limitation, the ground for the change of primary for the older child is limited preference plus best interest.
So are we following the Administrative Procedures Act, or what are we following exactly? Because I don't understand the rules here.
Following the Texas Family Code, sir.
The Texas Family Code, which falls under the Administrative Procedures Act, does it not? So it doesn't fall under the Texas Administrative Procedures Act. It doesn't fall under constitutional law. It doesn't fall under, what exactly are you falling under?
Okay, sir, we're not gonna get into a conversation. I've made my ruling.
You've made a ruling?
I've made my ruling. You made a ruling objected to his pleadings. I partially sustained that ruling.
I object to that very specifically because under the provisions that you can rule under, you need a judge to sign off on any ruling or any recommendation by you in order for it to become an official order or ruling. It falls under the fact that there has to be a separation of any administrative procedure has to be separated under the Administrative Procedures Act, Section 5C. And it says that the functions are separated. So you yourself can't just order anything. You have to have a sign off on whatever it is that you recommend as an order by the Judge Kim Cooks.
The family code gives me authority to render and sign temporary.
Well, if you're going to go under the family code, then under the family code, you have to be able to be ruling with no bias or impartiality. And under the way that the associate judge functions under the family code, you have a conflict of interest that should require you to completely and recuse yourself, which you have failed to do.
I have no conflict of interest. Your motion to recuse has already been denied.
It was denied on a technicality, and none of the issues that I brought up was ever written about. And the judge that actually denied it, he himself failed to adhere to the procedure of 18A through 18B. He never gave anybody the notice of the hearing, and nobody was able to see what was ruled on or not. His ruling is
That's another issue that's not before me, so we are proceeding at this time. You'll each have 30 minutes. Do we have any new witnesses?
I don't have any new witnesses other than myself for attorney's fees, Your Honor.
Okay. Very well then. I'm taking the parties as under oath as I previously sworn them in at the prior meeting in August. I'm not going to repeat that function. Mr. Conacher, you're the movement, so you get to go first and you get to call witnesses on your behalf. 30 minutes per side. That's for questions, an argument, and evidence and testimony. So you may proceed, Mr. Conacher.
Thank you, Your Honor. At this time, I've moved the introduction of P1 or summary request for relief into evidence.
Any objection to P1?
I object to the fact that Mr. Conacher here is the one that's making all the and putting in facts into the record because he doesn't have firsthand knowledge of anything. He shouldn't be able to be, putting any facts into the record. The person that's the one that's making the accusation should do that, and I have the right to examine that person.
Give me one moment, please. Was that from your email from yesterday, P1, summary of requested relief?
Yes, Your Honor.
And I'll sustain there's no predicate evidence to support the entry of this into evidence at this time, so the objection is sustained.
Okay. Your Honor, at this time, I would call my client, Ms. Rhonda Doe. Go ahead. Ma'am, can you hear me? Unmute yourself, please.
Yes, I can.
Okay. Ma'am, after the last hearing, on August the 17th, 2020, when was the next time Mr. Olivas saw the children?
We saw them that weekend.
I'm sorry, you have to say it again, it was muffled.
He saw them that weekend.
And did he text you on August the 20th of 2020?
I object. What part of this has to do with the original reason why the lawsuit was filed? If we're hearing evidence from the moment that the lawsuit was filed on forward, then we're not figuring out why the original lawsuit was filed. I haven't heard anything about why the cause of action for this lawsuit happened to begin with. On what grounds? Or give me a law that you're going off of, or would you have to give a explanation of what law you're going off of, or what a fact that's before you to So you're completely lawless then?
Next question. Ma'am, I'll just repeat that for clarity. Did Mr. Olivas text you on August 20th of 2020?
Yes, he did.
Did he also text you in November of 2020?
Yes, he did.
Have you previously reviewed what's been marked by identification as P2 and P4? What are those documents generally?
There are text messages between Mr. Olivas.
Okay. Do you regularly communicate with Mr. Olivas via text messages?
Yes.
Do you have any reason to believe that anyone else other than Mr. Olivas is communicating with you in those messages?
No.
Are the messages contained in those documents true and correct copies of the messages contained on your phone?
Yes.
Have any alterations been made to those
Objection. That record is not fully given, and there's not a full record of what the text messages all entail. So you can't admit something that's partially, cut off from the rest. If it's not complete, then how is that evidence?
That's an objection to the rule of lawful completeness. That's not the rule of exclusion, it's a rule of inclusion. So the objection's overruled. And Your Honor, I'm somehow moved to admit P2 and P4 into evidence. Any other objection to P2 and P4, sir?
Yeah, I object to the fact that this has nothing to do with the original reason why a lawsuit was followed, and has everything to do with, defamation of character at this point, and it's not even a complete recollection of the full transcript of messages.
Okay, give me 1 moment, please. Okay, objection's overruled, very good. And by finishing it up, don't review the message asking to take this proof. Ma'am, Your Honor, may I please share my screen? Yes. Go ahead. Thank you. Ma'am, can you see this document on your screen? At the top of the first page of P2, dated August 20th of 2020, generally, what is Mr. Olivas saying here at the top?
He stated that he hasn't done anything wrong and that I'm hurting him.
I'm sorry, ma'am. Can you repeat that? It came across as kind of muffled.
He stated that he hadn't done anything wrong and that I'm hurting him.
Okay, that's totally distorted. I can't understand any of it. Did the respondent mute himself? I think we're getting some feedback, Your Honor. No, we can't mute because he has to have the ability to object. I mean, you could unmute to object, but I mean, the only problem is coming out of Mr. window. Let me try again, Your Honor. Ma'am, can you see this document on P2?
Yes.
Yeah, that sounded better. Okay, and ma'am, on the top of P2, what is Mr. Olivas saying here under the date August 20th of 2020?
He stated he hadn't done anything wrong and that I'm hurting my children.
Then continuing from the first page into the second page, what is he asking you to do?
He wanted to speak with me.
Okay, and at the bottom of the second page, what is the last message saying? Last message that's saying here?
There's an objection to this because the plaintiff has asked for me to work things out outside of court, and that's part of their petition. And every attempt that I have made in order to speak with either of them or any of them, which they have not reached out to me to figure out what's going on here, has been met with either a deliberate attempt at cutting off what I say or submitting it as evidence to defame what I'm trying to do. But I'm not the one that ordered the petition for figuring it out outside of court. They did, which is not exactly what they're doing. They're doing the complete opposite.
Okay, the objection is, as far as the evidence being admissible under the questions overruled on those other relevant facts that the court will consider as testimony from Mr. Olivas when he gets to testify. Good. Ma'am, the last messages that are contained on the bottom of page 2, what does Mr. Olivas say at 7:24 p.m.?
He let him know that he was not stopped.
Again, Your Honor, I'm getting some weird feedback. Ma'am, what do you say at 7:28 p.m.?
I asked him if he knew that the decree said at 6 o'clock.
And what does he say in response to that at 9:24 p.m.?
And you know you don't hear. I want the decree so don't quote it to me.
Generally, ma'am, is Mr. Olivas on time to see the children?
No.
Okay. Is what he's referring to here, is this a one-off occurrence, or does this happen multiple times?
Multiple times.
And was there a phone call?
Objection. That in itself is completely misleading because Rhonda Doe has actually called the cops on me and withheld my kids from me for no reason at all, and that's in violation of the divorce decree, and that was in my evidence from the first hearing, which I did submit and was allowed. So I even gave a proper notice to Rhonda Doe when she started doing that and withholding my kids. So the fact that you want to defame me and say that I was late for whatever doesn't constitute any sort of notice from Rhonda Doe as per the decree in regard to anything that happens to be an issue.
Okay. As far as the misleading objection that's overruled, however, Mr. Olivas, save that part of the testimony, have a chance to testify to all of this. Okay, next question. Thank you. Next up, was there a phone call? And was there a phone call between you and Mr. Olivas on August 21st of 2020?
Yes.
Was there a conversation between you and Mr. Olivas on September 20th of 2020?
Yes.
Did you make a recording of the phone conversation on August 21st of 2020 between you and Mr. Olivas?
Yes.
Did you make a recording of the in-person conversation between you and Mr. Olivas on September 20th of 2020?
Yes.
And are those recordings contained in what's been marked for identification as P3, P5, and P6?
Yes.
Whose voices are contained on those recordings?
Mine and George Olivas.
And just generally, when were those recordings made?
During that time of the conversation.
Was that on August 21st and August 20th? Okay. Are those recordings an authentic and correct recording of the conversations that took place on August 21st and September 20th?
Objection. They're not complete. Like I said, they are not complete. They are cut off at key points, and that was an attempt on my part, talking to her, to figure out what resolution to this issue was, because to my knowledge, I had no idea she was even going to sue me, which is in contrary to the decree that she's supposed to be following.
I can't, unless I hear them, I can't move on the cut-off nature of them. I can't move on the cut-off nature point here. As far as optional, that's the extent of the ruling at this time, unless there's further work that aspect. Thank you, Your Honor. Ma'am, were the conversations that took place in those recordings made voluntarily and in good faith without any inducement?
Yes.
Have any alterations been made to those recordings?
No.
Objection.
Your Honor,
She didn't submit the full recording. She didn't submit the full recording, and therefore she cannot say that no modification was done. She definitely modified it, and she definitely cut it off at key points. So she cannot truthfully say that she did not modify them.
Or weighs the evidence as far as what's truthful and what's not. If you actually prove it.
And you're right, to somehow you would admit P3, P5, and P6 evidence unless the court requires I play them.
I object to the simple of matter that they're not complete and that doesn't accurately represent everything that happened on those conversations. But
Okay. I'll provisionally allow them to be played and I'll condition once I hear them.
Okay. Let's try this again, Your Honor. Let's see here. There we go. And should computer sound. Okay. I'm going to play what's been monitored as P3.
The only thing that I can do at this point is I've let
Can everyone hear that? Yes. Okay. We're going to continue playing.
the case run its course. At this point, just going to submit an enforcement clause, and the court's just literally going to modify what the original petition was. And since they have this judge that wasn't acting in the weight of the law at all, I've set up a different other motion, and he's gonna have to prove his personal jurisdiction, and he's just gonna have to prove whether he's actually acting as a judge or not, and he'll be liable for that. I don't know what that will show, but he's essentially gonna get thrown off the case. It'll get into judge, actual judicial judge, and then the enforcement clause is gonna come into play. Under the enforcement clause, they're gonna look at very specifically just enforcing it, and if one of us is in contempt of court, then they will at that point use the decree itself and the penalties stated herein to figure out what the contempt of court charge is gonna be. They can't modify it, they can't change it, they can't do anything that. Yep,
Okay.
I'm almost done. So, I read you the law and I read you the decree
I
at
know
both
the
times,
decree.
and like I said,
Hold on, can I speak? I read the decree. I know what the decree says. But the decree was anticipated that you follow through on what you decided was best for the kids. You have not been following that. That is why I got a lawyer and to help us fix the situation. And I'm just going to leave it at that.
the only thing that I
What in that recording? What is Rita saying?
that recording in itself showed how she's modified the recording and cut it off, even in her middle of her own words, to not hear the rebuttal after what she said. That's a modified recording, and it does not play out the full conversation of what was said.
Objection is overruled, however, you have a chance to testify to what the remainder of the court said.
Ma'am, you can answer the question. I have to. Is Mr. Oliva saying after that in this recording?
He stated that the judge was enacting a criminal law, and then he was going to file some sort of
Okay, stop. Go ahead, Deanna.
I think he needs to. He stated that the judge wasn't acting according to the law, and that he was going to file some sort of motion and stuff.
And again, ma'am, has Mr. Olivas actually followed the terms of the final order with respect to possession of the children, or no?
No.
Objection. She's completely generalizing everything, whereas she herself has been in very serious violation of the decree, becoming even from where she lives and who she lives with, being a registered sex offender and not notifying the court or anyone else. So she's in a very big violation of the divorce decree, and she cannot say that just simply a couple of modifications that we agreed on were or are going to modify the parent-child relationship just because she now feels that she wants to go after a financial thing where even that was agreed upon in the decree.
Okay. As far as being admissible evidence, the objection is overruled, we testify to those views.
And Your Honor, just so I understand, I did move to admit B3 into evidence. The court edited this. Okay. I'm going to share my screen again, Your Honor. I'm going to play what's marked identification as B5 for the court. Yes, you can ask whatever questions you want. And Your Honor, before I play that, can you please have the respondent's mic feed? I still think we're getting feedback from his audio.
I've been muting my microphone the whole time. I keep putting it on mute, and that doesn't make a difference. But I object to these recordings because they're all after the fact of the lawsuit that was filed. There's nothing before the lawsuit. Why are we looking at anything that's required? Anything that's dated after the lawsuit was filed. I still want to know what the cause of the lawsuit to begin with was, or what I did to exactly have this be an issue at this point. Again, you're noticing that these all recordings are cut off at very strategic points. I don't see how this is admissible evidence if she's not going to play the full thing. That none of these recordings are in succession from one another, and they're all incomplete. How is this evidence? Yeah, plenty of it. That was a 40. That was.
So we only have 30 minutes to stop. Mr. Davis, you wanted to play the rest of that time, but it's going to take up the rest of your time.
Well, the reason why I'm objecting to it is because this is incomplete. How is she only going to admit a part of the conversation when it was a 3-hour long attempt at trying to figure out what's going on and what to do about it? So I don't see how this is an admissible.
Your entitlement to have it is stated if you want. Are the entire communications in the past that you sent
I'm sorry, what?
Mr. Conover, is the entire communication in the past?
It was no, Your Honor. It was they sent via email. We're talking about the 3-hour conversation.
Promise to stay in the agenda.
Um, Ma'am, during this period of time prior to the lawsuit being filed, did you have a way to contact Mr. Olivas?
No.
Objection. We've had plenty of communication via different means, and she was never not able to contact me. In fact, she did so several times through different means, but she always had my phone number, and she always had a way to communicate me if need be. There is no reason why she can say that she wasn't able to communicate with me.
Ma'am, during that period of time prior to this lawsuit being filed, did Mr. Olivas provide you any updated phone number for you to use to contact him?
No.
Objection. That's not a truthful statement.
Ma'am, during this period of time prior to the lawsuit being filed, did you change your phone number?
No.
Did you change your residence?
No.
During this period of time, when I keep referring to a period of time, I'm referring to the period of time Mr. Olivas wasn't coming around. How long was that?
Objection. I wasn't not coming around. That's a false statement.
The court is not making a set of things straight. It's true that she had testified.
He was, sorry, can you, ask the question again?
When I refer to period of time prior to the lawsuit being filed, I'm referring to the period of time when Mr. Olivas was not exercising his possession of the children. How long of a period of time am I talking about so the court understands?
It was about a year, and then he came back and explained the situation to me, and then he was at, another store.
During that period of time, Mr. Olivas spent any money to help with child expenses.
No.
Do you recall testifying at the last hearing regarding your monthly expenses?
No.
Was your testimony at that time with respect to your net income, was it $1,682 each month? And from your testimony from the last hearing, were your total necessary living expenses $1,660 each month? Does that mean you have less than $100 each month to spend? And with that being said,
Objection.
are you... What's your objection?
He's trying to make it look like she has 100% of the expenses, and in reality, she does not, because every time they're with me, she never sends money this way. Therefore, anytime they're with me, she doesn't run the expenses, and that's the whole point of the final decree of divorce being no child support needed, because when they're with me, I pay for my expenses, and when they're with her, she pays for hers. So the whole conjecture of did he pay for that is obviously no, because that's the whole protection of the final decree of divorce. You have to share the children in order to share the expense, and she has been withholding the kids from me. That's the whole point I'm making. She's been withholding them from me.
Okay, again, not in the nature of a legal objection, in the nature of testimony, so that court can consider testimony to that extent, but it's not an objection to her.
Objection. Again, she has cut off the communication between. That's not the full transcript of the text messages. It's not it's not a complete transcript of it, and I don't see how this is relevant to the reason why the lawsuit was filed to begin with.
Your Honor, I think I already admitted P2 and P4 in the evidence. Am I incorrect? Yes. Okay. Well, I will let it predicate to the P4. Ma'am, I'm showing this mark for identification as P4 as 1. Someone say something. I'm showing this mark for identification as P4. What is the document? Do you regularly communicate with your Olivas via text messages?
Yes.
Do you have any reason to believe that anyone else other than Mr. Olivas is communicating with you in these messages?
No.
Are the messages contained in the document a true correct copy of the messages contained on the phone?
Yes.
Have any alterations made to these messages?
No.
Your Honor, at this time I do submit B4 to evidence. Objections?
No objections. I do agree with what the communication states. Therefore, because she does live with a registered sex offender and she's filing a lawsuit in the interest of Ivan and Ruben, but then lives with a sex offender. So, no, I don't object to the admission of that exhibit.
Okay, submitted. Ma'am, on the second page, what is Mr. Olivas generally saying on the second page?
He basically wanted to drop them off. And if not, then he was going to disclose my stepdad situation and other things.
So, what is this stepdad situation he's referring to here?
When I was about 11 or 12, my stepdad got
Okay, stop for a moment. Go ahead, start again. What is the stepdad situation that is being referred to here?
when I was about 11 or 12, my stepdad got in trouble for touching my sister inappropriately.
And how old are you now?
I'm 30.
Does your stepdad, does he come near your children?
Yes.
Okay. How often does that happen?
Like once a week.
Are the children ever left in his care without you being present?
No.
Objection.
Ma'am,
That's
continuing on.
objectionable because nobody can verify whether that's a true statement or not. She's the only one that would know that, and there's no one ever to verify the fact that whether she does or does not leave them in his care. The fact that she lives with the registered sex offender and does not disclose that to the court, even though she's supposed to, as per the divorce decree, is just not correct at all.
Objection's overruled. Do you live with your stepdad, ma'am?
No, I do not.
I'm going to bring your attention to the fourth page of P4. Generally speaking, in this long paragraph, what is Mr. Olivas saying here?
He basically told me I was accused of using drugs and using drugs.
Okay. Are you concerned about any drug use on the part of Mr. Olivas?
Yes.
Objection.
Why is that?
I don't use drugs, and she has no proof of anything of the sort, no evidence to prove it. And no one's ever seen me, or I don't even have a criminal record to begin with, never been arrested. I've never had any sort of affiliation with drugs to say that I am it's an allegation that's unsubstantiated. It's a defamation of character, and I don't see why we're talking about this if she can't prove it.
I'll take that as an objection to her lack of personal knowledge. You can answer the question. I'll consider the objection as you answer.
So I asked you, ma'am, why are you concerned about any alleged drug use in Mr. Olivas?
Because for that time where he was working around, he told me that
Let me try this.
Objection. That's not factual. That's not correct. She's not stating anything that she has firsthand knowledge of or has evidence of in any way. I don't see why this is relevant. And I did not get involved with any drug cartel.
The statement by party opponents admissible. So the objection sustained otherwise.
Ma'am, did Mr. Olivas tell you anything about a drug cartel involvement or not?
Objection. She has no. I did not get involved with a drug cartel. She doesn't have any evidence of any sort of drug affiliation. I don't even have a criminal record. Never been arrested. Never been anything. I don't have a criminal record. I don't see why we're talking about allegations that are unsubstantiated by any evidence.
You can answer the question now.
Yes, he did tell me that.
Do you know how he got involved with drug cartel at all?
He told me he started working with a gentleman that apparently was involved. And he mentioned that the guy helped fix his car. And so he had stayed over at his apartment one night and left some of his belongings there. And when he was informed to go up the possession, the guy didn't, and they ended up opening it and seeing that it was drugs.
Objection. That's not factual. I never stated that.
Ma'am, according to this fourth page of P4, are you trying to strip Mr. Olivas of all father's rights as claimed?
No.
Objection. That's verifiable by her own paperwork, where she says that she wants to strip away all the ability and to be a father, and she wants supervised visits as if I were a criminal. That's something that you could see in her own paperwork. She's trying to do. That's not correct.
Ma'am, specifically, are you asking for Mr. Olivas to begin paying child support under the child support guidelines? What kind of health experience do the children have? Are you asking Mr. Olivas to submit to a drug screening at a still cost? And for those results to be shared with the court and your attorney? And subject
Objection. What is the probable cause for any of that? What evidence does she have for any of that? Why do I have to subject my body for search and seizure under no actual evidence of any fact? She just stated she had no firsthand knowledge of any sort of drug use, so why should I, with no probable cause, submit to anything? That's a violation of my body and...
Ma'am, it's subject to the results of the drug screening if the court orders that. If Mr. Olivas tests clean, are you okay with him having possession of the children under a standard possession schedule?
Yes.
What kind of possession schedule do you have right now with Mr. Olivas?
According to the decree, it's without any God.
And has that worked?
No.
When was the first time he started exercising possession of the children again after that period of time he was absent?
July.
July of what year?
2020.
Okay. How long had it been before he started exercising his possession of the children again?
Over years.
Objection. She was also withholding my sons from me. And in fact, I actually sent a formal notice where I talk about how she's been withholding my sons from me, and it's not factual what she's saying because she withheld them from me. I just didn't go through and call the cops on her that she did.
Objection to the testimony. Mr. Has Mr. Olivas been exercising his possession of the son who got regularly this year, 2020?
No.
objection. She's supposed to pick up and I'm supposed to drop off. How is that relevant to whether or not we pick up or drop off? Because we're supposed to trade off that way. It's part of the decree.
Yeah, you were just on that on Saturday, and then I can come up on Sunday.
Has Mr. Oliva been exercising the full amount of his week-long job possession this year?
No.
Are you asking for this court to order a child custody evaluation through Dallas Family Court Services?
No.
Ma'am, are your requests for what you want the court to do today, are they contained with the marked identification T1?
Yes.
Is that document a summary of all the requests you're asking this court to do today for temporary orders?
Yes.
Your Honor, at this time I approve to admit B1, a summary of requests of relief. Actions just to the summary.
I just, like I said, I want to refer back to the fact that she sued me based on the, you know,
Hold on a second. You're going to have a chance to testify on this. I'm just legal objection to the summary coming in there.
I mean, I object to the summary and the basis that she's got nothing to prove. She's got no evidence of anything that she's asking for, and it's kind of erroneous to prove a negative. How do you prove you're innocent?
The summary is admitted just demonstratively as far as what number one. Thank you, Your Honor. And, ma'am, has Mr. Olivas discussed the litigation, this litigation with the children still?
Yes, yes.
Did that happen even after the last hearing on August the 17th of 2020?
Yes.
How often since that hearing has Mr. Oliva discussed this case with the children?
Pretty much every time we see them.
No further questions, Your Honor. I pass the witness. You're out of time also. Thank you. So, Mr. Olivas, at this time you can ask her questions if you would like to ask her. The testimony you want to offer, make sure you save time, because if you spend the whole time asking questions, you won't have any time to testify.
I'd like to ask her very specifically, does she have any firsthand knowledge or proof that I do drugs or am a drug addict, as she says, and am involved with the drug trade?
All I have to go,
It's a yes or no. Do you have firsthand knowledge that I'm involved in the drug trade, that I use drugs, or that I, in any way, shape, or form, am involved with criminal activity? Firsthand knowledge? No. Are any of the allegations you're making on your petition in regard to accusations of drug use or criminality on a firsthand knowledge basis?
suspicion. I mean, okay, sorry, can you reword?
Do you have any firsthand knowledge at all in any way, shape, or form in regard to evidence that I'm involved with any kind of criminality? No. Are the allegations made in regard to criminality a way of defaming or making me look bad so that you can get the petition on your side? So if you don't have any firsthand knowledge, how is it not to make someone look bad or defame them what you put as an allegation?
Well, because you told me and further
I told you what exactly?
Objection. Witness not allowed to finish the answer. Finish the answer first.
you told me that you were gone. The first, that first time.
I told you what?
You told me the reason why you were gone.
And that was that I was involved with criminality?
That you got caught up with someone that was involved in the drug.
Did I tell you that I was threatened by someone.
Yes.
Okay. Was it me being involved with them, or was them threatening me?
Objection. She likes personal knowledge about that. She can testify to anything that Mr. Alita stated. Other than that, personal knowledge.
So, in general, the allegations of criminality are unsubstantiated as far as we can understand. Yes or no?
What was the question?
As far as all the allegations you make of criminality on my part, they're unsubstantiated. They're just simply allegations.
Based on what you said, you told me yes.
Are they unsubstantiated with evidence, or are they allegations?
I don't have evidence.
You don't have any evidence. Do you have any firsthand knowledge that I'm involved with criminality on you witnessing me being a criminal? No. Okay. Is there any reason why you allege criminality without having firsthand knowledge on a court paper or a petition that's going to go and be submitted through the court?
Because you firsthand told me, and I want my kids to see
I told you what exactly?
that you were involved with people who were.
I'm sorry. We've asked and answered this. You said that I was threatened, and I told you I was threatened. I did not tell you that. Did I or did I not tell you that I was involved in criminality, or that I was threatened?
You were involved with people that were involved in all that. So,
I told you I was involved with criminality, or I told you I was being threatened. Which is it?
you that you were involved with someone who had involvement with stuff.
So I told you that I was being threatened. I did not tell you that I was being involved in that criminal activity. Do I have a criminal record, Rhonda?
I'm not sure. To my knowledge,
Okay. So I'm going to move on from this because there's no point to continuing this line of questioning. But does your stepfather, is he a registered sex offender?
yes.
Does he visit the house regularly?
Like once a week.
Does he have a restraining order against your family members?
I don't know the details behind that.
You don't know the details of your stepdad.
No, I was 11 or 12 around that. I know the situation, but he does not live with us.
Does he go over routinely enough to visit your mom?
He comes and helps around the house.
Okay. So we can say that he's part of your daily lives?
No, he comes when we see things around the house that he uses.
Does he have another residence that he's supposed to be at all times instead of being at your residence? Does he have a formal residence he's supposed to check in with?
He lives in his own apartment.
Okay. Does he still have a probation officer?
He doesn't live here. I think he has his own apartment.
So does he have a parole officer at this point?
I don't know. I don't know the details behind it.
So can we say that you filed a lawsuit for in the interest of your children, yet the sex offender that goes and visits your house regularly, you don't have any idea what the deal is with that?
My kids are never they're never around him, and he does not live with us.
But you don't know what's going on with him.
My sister told me that I'm sorry, I don't know the legal terms, and I was really young when that happened. But to my knowledge, probation and whatever is over. He's done his
So you file a lawsuit for the interest of your children, yet you don't know what's going on with a sex offender that regularly visits your home. Is that
Asked and answered.
I'll rephrase the question if need be. Is it accurate to say that even though you're filing a lawsuit in the interest of Ivan and Ruben, you don't really have an idea of the full extent of the record of criminality that a child sex offender has that visits your house regularly?
I don't know the details, but my sister has told me that his
That's hearsay.
reputation.
It's the hearsay. Yeah, you can't say what other people have said.
Oh, sorry.
Well, the answer, the question's been answered, the answer is no.
Lastly, I'd like to just simply ask Rhonda Doe if, for the reason being for the fraudulent signature that's at the end of submitted evidence by Conker at the back of a divorce decree that he resubmitted, where my signature was forged on the last page of that submission of evidence. And also a notary seal stamp was forged as evidence of me giving up the my parental rights or my parental.
Shit on it. The city of facts, not in evidence and relevance.
Well, you submitted the evidence. You're
It's not evidence. That's the court's not going to consider it. Unless it's admitted.
well. I'll rephrase the question. If we're doing things in the interest of Ivan and Ruben, and everything that I've done in general, and even in the divorce decree, have been in the interest of Ivan and Ruben, how is it that she's saying now that I'm not doing things in the interest of my sons?
I'm not stating that you're not doing things in the best interest of your employee. All I'm asking is to have the decree modified to allow me to have primary custody so I can do everything I need to do for the boys as I've been doing for years. And then also for you to help financially because the boys do need that as well.
So you're saying you're saying that I never helped you financially.
In the past you have.
Okay. Did I ever help you with your schedule while you were going to school as well? Picking up and dropping off the Ivan and Ruben. Whenever it came time to either have and subject my sons to being driven for half an hour in the mornings and 45 minutes in the mornings just because I wanted to have them on a weekly basis. And it was closer for you to have them at that point. Did I not choose what was in the best interest of my sons and agreed to keep them with you, but at the same time helped you financially when I did that?
You did, and I
So
but as far as the financial, you did not always help.
is it that I helped you financially or did I not help you financially? Which is it?
For a period of time, yes.
During the time that I was helping you through your school and helping you drop off the kids to work around your school, and even when I decided that, at the moment it was, better for them to be 5 minutes away from their school versus 45 minutes away from their school, do you not call that me being there and present?
Yes, but at that time, ever.
Did you ever notify me of any kind of issues as in a formal notice of any type at all that you were having some sort of issue as per the divorce decree required? Was I ever notified of anything in a proper notice? Well, in the divorce decree, it says that before any sort of litigation, you're supposed to notice me of any sort of issue so that we can work it out. Did you ever do that formally?
I'm not really, but I would have
That question, he's misstating the document and on file with the court, what it requires.
The divorce decree is before the court because the original court that issued it was this court. So it's under the same court. How can you object to it being issued there or at all being brought up? That's why we're here.
It's one of your objections. I'm objecting to the characterization of the requirements of what the divorce decree requires as though they do prior to filing the lawsuit.
It does.
You have to get Mr.
It very specifically mentions that a notice has to be given to the other party if any litigation is ensued against the other party as a form of indemnifying each other or protecting each other's back. It's also a way of making sure that me and her can co-parent through any kind of issues freely and openly, which she never did. I never received a formal notice that she was having any sort of issue before I was sued, in violation of the court order she signed and agreed upon.
Do you have a page number beside you?
Yes, let me tell you, that would be in, it's, I believe 27. Let me double check that. I don't have it pulled up, but I believe it's page 27 or 20, 1 second. One second, I'm pulling it up now. I didn't have it pulled up before. I'm sorry, what? So, there, 1 second. Okay. There were several provisions in the decree that are supposed to protect both myself and her in order for us to co-parent freely and openly. And their protections are in the fact that we have to notice each other, or first, before any sort of litigation be ensued, let each other know what the issues are so we can freely and openly work through whatever issues are happening. And she has never abided by it. And it's a way of protecting not only one another, but it helps us co-parent. Give me 1 second. I'm working through it. I didn't have it pulled up in front of me. Just give me a second. I'll give you that provision. It's on page 21, and it's the second paragraph. It says, "Notice shall be given to the other party by delivery of registered certified mail. Return receipt requested." No, that's not it. One sec. Okay, it's on page 28, and it's near the last two paragraphs. It says, the parties agree to, and it is ordered that each party will give the other party prompt written notice of any litigation threatened or instituted against either party that might constitute the basis of a claim for indemnity under this decree.
Objection as a basis for claim of indemnity. The indemnity is only with regards to the threat. The objection is thank you.
Is she not suing for money at the moment?
That has to deal with the division of property and debts.
Correct, but right under that paragraph, it also says that it is ordered and decreed that all relief requested in the case not expressly granted is denied. And that is a final judgment.
That was brought up at that time. But let's move on to the next question.
It also mentions that the judgment, it finally deposes of all claims and parties and is appealable, yet she never appealed it. She also never went and,
No, that's fine.
well,
I'm just asking, if you have any more questions, just go.
yeah, I want to know if she ever appealed it. Did she ever make a formal appeal? Did she ever make any formal notice to me that anything was amiss with her in regard to issues she was trying to work with? Written form. I'm sorry, the question is, did you ever make a notice, a proper notice, through the mail, through text, a formal notice, letting me know that you were having issues that we could work through together and let me know beforehand? Have you actively tried to communicate with me and genuinely sat there and spoke to me about things that are relevant to Ivan and Ruben instead of just trying to argue and fight? You have. In what instance did you ever also tell me that financially you were having issues and noticed me of that issue? And the one time that I remember it happening, I actually signed over the tax credit to you because you said you wanted more money.
He's testifying at this point, Your Honor. You have more questions, Mr. David?
Did Rhonda Doe ever notice me of any issues that she was having so that we could work through it instead of just suing me, which is in contrary to the decree?
Yes, I have multiple occasions.
Do you have any proof of said notices?
No, because I don't know details and concerns and facts.
So are they proper notices, or are they you sitting down or saying that we verbally sat down and talked about them but have no way of proving them?
I'm going to back to the line of questioning as to the relevance of the issues before the board.
The relevance of the issue is specifically,
The objection's overruled and it's relevant.
mainly I'm trying to show that I at this point am the one sitting at this end getting sued for whatever reason she decided to sue me for, but she hasn't communicated with me or actively sought for actual communication to fix any sort of issues.
I don't really object. You can ask the question.
Rhonda, did you ever actively sit there and try to let me know beforehand what problems you were having so that we could work through it in a formal notice?
We sat down. What your question was, did we ever sit down and have a conversation? Yes, we have sat down and have a conversation.
No. My question is, did you ever send me a notice of the issues you were having so that we could work through them? The way that I've sent you notices in written form whenever I'm having an issue with whatever you're doing.
No, I have never seen a written.
Okay. Do you have any proof of the fact that you actually tried to work through do you have any sort of communications that you can prove that you actively try to work with me on stuff, or any sort of proof that you tried to communicate with me in general?
Yeah, we've had multiple conversations.
because you've submitted plenty of text messages I sent you, but you're not submitting any evidence that you sent me text messages in communication to anything.
Right, because every text message that you send me is threatening me with one thing after another. And
Right.
when we speak, I never get a chance to speak. It's always jump the lawsuit, jump the lawsuit, jump the lawsuit. And I can never speak my part.
I threatened you of doing what?
Like you threatened to bring this back up, like for example, with the refusal of the judge, my attorney, my stepdad, and now that I saw your signature, it's always one thing after another. And so I don't think that if you really wanted to work with me, that every time we speak, you would throw something like that out. That's not co-parenting. You don't listen to my side of the story. You don't listen to what me and the boys need. I came to you, and we've established that the boys have been living with me for many, many years. I've tried to work out with you all those years, but you never work with me, and I have to go through this route now. I don't want to do this, but I have to do it now for the boys.
At what point in time? At what point in time did you? Did I threaten you for any reason that you didn't do something like, use my information without my authorization for whatever reason, my social security number? Is that proper?
For the child support, when I had a conversation with you about child support, you told me go file, so I did it,
No.
but I never went through with it.
Did you use my social security number and personal information for any reason without my authorization?
I went to the office of attorney through the child support office website and put in the information that they asked for them.
So you used my personal information without my authorization, which I received mail from that office, and then I told you that you were committing identity theft because I never gave authorization. Is that what you're referring to when I say threatened you with a lawsuit?
I submitted what the website asked for, the child support website.
Is that what you're referring to when you say that I threatened a lawsuit?
You told me I was going to go to jail for identity theft for putting in your information that they asked.
It's a yes or no question. Is that what you're referring to when you say I threatened you with a lawsuit? Is for using my personal information? Okay. Did I ever threaten a lawsuit for any other reason than when I talked to you about either enforcement of the decree or any sort of you using my information without my authorization? Have I ever threatened you with any lawsuit aside from those two things?
Now you're saying that I saw your signature and that I was going to get in trouble for that. You told the boys that.
Like I said, have I ever threatened you with a lawsuit outside of the fact that I was either trying to enforce the decree or you used my information, personal information, without my authorization?
No.
No. So anytime I threatened a lawsuit was because you were acting outside the decree or because you were using my personal information. Is that correct?
That's the child support office.
It's a yes or no question. Did I ever threaten a lawsuit outside of the fact that I was either trying to enforce the decree or you were using my personal information? No. Okay, so I never ever threatened you aside from those two things, correct? Just to reiterate. Okay. So we've established that I threatened only under enforcement or using my personal information. We've established that I don't have and you don't have any evidence of criminal activity of any sort or me being involved in anything. And we've also established that you didn't ever notice me of any issues formally in a written form the way that I have noticed you. Is that correct? Okay. Lastly, do do you agree or disagree that from the get-go after the divorce, I acted in the way that would benefit not only yourself, but my sons, and by way of them also protect each other? And it was done so in the most fair way by giving you, joint custody and having the same rights I do.
Yes, it was in the best interest of the kids.
Okay. Was it? Go ahead.
And it was in the best interest of the kids that you allow them to live with me, but it was on the ground that we help each other and the agreement that we would also benefit.
So, did you ever in turn feel that I was doing something just to hurt you in anything that was formal and paperwork done for the courts and what I chose to do with my sons and yourself? Was I ever doing anything malicious in that way to you?
Sorry, I don't understand the question.
In doing everything that I have done, have I ever acted maliciously to hurt you directly for some reason or another while using my kids to do so?
In the past, no.
Okay. In what way have I done so even in the present?
Because you were, the kids needed things that you didn't help provide.
Did you ever give me notice of those things? Formally, written? Okay.
No, but
So how was I supposed to know that you needed help financially or otherwise if you never gave me formal notice under the divorce decree as you were supposed to?
because I always thought that if you were received the plan correctly, I wouldn't have to write you letters. You can sit down and have a collaborative conversation.
Didn't you say that you had no way of communicating with me, and you said that you had no ability to communicate for a long period of time, while at the same time saying that I was the one that disappeared?
Yes, when you were gone, I did not have Jennifer.
So how is that a possibility if you say that you've actively tried to communicate? How do you say that I disappeared and you couldn't communicate, and at the same time you say that you actively communicated?
I communicated with you in the past. Back in 2017, when you wanted to call, you used your number, and I didn't have the number at that period of time.
Did you have any other numbers in which you communicated with me through, for instance, my dad's number, my sister's number, my aunt's number, my uncle's numbers? I mean, you have a complete record of my entire family, and you say you couldn't communicate with me?
I can communicate with your family, but when I'm thinking me, you directly, I feel like I shouldn't have to go as co-parents, right? I don't think I should go to your family to try to communicate with you.
And at the same time, you say that you co-parent with me, but you feel like you don't have to communicate with me through, you know what? Scratch that question. Have I ever not answered your calls whenever you call or text?
You have, yes, there's been a period of time where you answered that call.
For instance, whenever there's something going on that is kind of serious, like inclement weather, do I not, or do I check on you guys just to make sure you guys are good?
You did that once recently.
Have I ever just disregarded whenever there's something going on with you that needs assistance?
Yes, for the 2.5 years or so that you were gone, there were things that happened that you weren't involved and you didn't know, and I couldn't reach out to you.
Well, for instance, did I not offer to go and for instance, put the kids' bed together when you had issues doing that? Hello?